Welcome, everybody. My name is Alan Johnson. I'm Chief Assistant State Attorney in the 15th Judicial Circuit here in Florida. I'm here to talk to you about discovery, Brady and Giglio. Three distinct concepts. We're talking about regulatory discovery. We're talking about by rule and statute. We're talking about constitutional, which is Brady and Giglio. And then sprinkled in there are ethical obligations of all lawyers, but specific ethical obligations of the prosecutor. Now, first, let's talk about the rules of discovery. It's contained in Rule 3.220, the defendant may elect to participate in discovery by demand or by his actions. In other words, a demand for discovery, all defense attorneys are aware, or if a deposition is taken or if a public records request is made, that will trigger what's called reciprocal discovery, which means that the defense has an obligation, as well as the state, to supply information regarding the case at hand. Now, let's talk first about the prosecutor's obligation, because there's a lot of them, and there's only one short section on the defense. But let's talk about B1, 3.220. That's the meat. Within 15 days after service of the notice of discovery, the prosecutor shall serve a written discovery exhibit which shall disclose to the defendant and permit the defendant to inspect, copy, test, and photograph. Now, most circuits in the state of Florida will give paper discovery, all the reports, all the actual written discovery, and including statements, tape statements, and the like. But the rule talks about permitting the inspection. We bypass the middleman in that regard in the 15th. First, a list of witnesses, all persons known by the prosecutor to have information regarding the case. That is not a state witness list. It's a discovery witness list. Some people make that mistake. I mean, literally, the defendant is a witness, technically, because the defendant may have knowledge about the facts of a particular case. So we list everybody. We're supposed to list everybody that we are aware that have any knowledge regarding this case. Not necessarily a trial witness list, obviously. B, statements of any witnesses, written, recorded, or summarized. Statements include all police and investigative reports. Statements of the defendant and whom the statements to whom made. Co-defendant statements. Grand jury minutes containing testimony of the defendant, tangible papers or objects obtained from the defendant, material or information provided by a CI. We'll talk about that. We'll expand on that in a second. Existence of electronic surveillance of the defendant's conversations or premises and any related documents. Search and seizure items, reports or statements of experts, if they exist at the time, including test results of physical or mental exams, scientific tests, experiments, or comparisons, any other tangible papers or objects intended to be used at trial. Any tangible paper, objects, or substances that could be tested for DNA. Obviously, they're listed. You're not going to send a blanket or a pair of pants in discovery, but the actual notice, the list of items that could be tested for DNA. Now, as I mentioned earlier, there's a separate rule regarding CI disclosures. Now, understand that this involves the CIs that the state intends to use at trial, intends to call a trial. So what material has to be disclosed? The substance of the defendant's statement to an informant, a summary of the criminal history of the informant, time and place of any statements, any benefit that's expected or had been received, prior history of cooperation by the informant in return for any benefit. And again, the intent of this rule was that it apply to the informants who are expected to testify. Matters not subject to disclosure under Rule 3.220. Work product, legal research, records, correspondence, reports, and the like that contain opinions and theories or conclusions of a prosecutor or the staff, the legal staff of that prosecutor. Informants, there's no requirement to disclose the identity of a CI unless the informant is going to appear at a hearing or a trial. or failure to disclose obviously would violate the constitutional rights of the defendant. That would be exculpatory information that has to be disclosed, and we'll discuss that in great length. Now, restricted disclosure, Rule 3.220b2, you can go for an in-camera determination that an investigative report contains irrelevant, sensitive information, or the disclosure may seriously impair law enforcement or jeopardize an investigation. An example of that would be a poll camera or intel that is involved in other ongoing investigations. And that would be taken in camera as to whether the state is required constitutionally or statutorily to release that information to the defendant. Rule 3.220e, the court may restrict disclosure where there is a substantial risk of personal harm, intimidation, bribery, economic reprisals. I love this line, or unnecessary annoyance or embarrassment resulting from the disclosure that outweighs any usefulness. Talk about personal social media posts. When you're determined, as we go through the rules of discovery and as we go through the case law, remember the elephant in the room is Marcy's Law, constitutional amendment that gives the victim of crime certain rights. And we'll discuss that later. But one of those rights is the right to withhold information about their identity to prevent harassment or the like. And that will be developed through case law because the constitutional rights of a defendant as opposed to the constitutional rights of a victim. But of course, the constitutional rights of a victim will outweigh the statutory rights of a defendant. So again, if things are withheld in discovery, the state can't then use that as a sword, so that undisclosed sensitive material will be generally prohibited from being used by the state in trial or at a hearing. Now, there's an ongoing duty to disclose. That's very important because at the outset of a case, within 15 days, and then the defense obligation as well, things come up during the course of an investigation, during the course of the discovery in a case. When things come up, there's an obligation that's ongoing for all lawyers in the case to comply with the rules of discovery as you receive information. Very briefly, category witnesses. Category A, they're fact witnesses. Witnesses that have knowledge, they're of specific firsthand knowledge that will be called to testify or may be called to testify. Category C is a witness that performed a ministerial or perfunctory action, and that witness has developed whatever they have done in a report or statement. And then category B is everybody else, which would be anyone not listed in A or C. And you might find some of those in officers on perimeter or transport logs where there's no report. The defendant has an obligation. There's this much in the state obligation, which the state is the moving party. The state is prosecuting the case, and nothing is hidden in Florida. As I said earlier, we have very liberal discovery rules, and there's no hide the ball in Florida. Defendant's obligation, which is in one section, within 15 days of receipt by the defendant of state's discovery exhibit, material to be used at trial needs to be disclosed. And remember, that's ongoing. List of witnesses defense intends to call at trial, and reports or statements of experts, including results of examinations and scientific tests. Again, those would be tests and examinations that the defense is going to use at trial or intends to use at trial. A key complaint of defense attorneys is the state is hiding the ball and not giving out exculpatory information. I hope that's not the case, because when it comes to exculpatory information, and I'm going to say this repeatedly during this training, when in doubt, give it out. Give it out. With the defense, though, one of the chief complaints of prosecutors is that the defense basically just lags. A witness list is handed to a prosecutor on the Friday before trial. Well, this is when my client gave me the witnesses. I get it, that sometimes happens, but defense attorneys have the ethical obligation to comply with the discovery rules and to comply with their other ethical obligations, as well as the prosecutor. So there should not be any hide the ball in terms of dilatory or gamesmanship on either side. Depositions, just briefly, in the 3.220, the location is the courthouse or a location that's agreed upon between the parties. Deposition should not be unilaterally set by either party. You know, we need to get along, and we should get along, both the defense bar and the prosecutors. The location is in the county where the witness resides. If your witness or a witness resides in a neighboring county, then that deposition needs to be set in the neighboring county. It can't be set in the courthouse of your county. It needs to be set within the rules. This is not a civil case. You know, we're talking criminal cases here. So depos are used differently, by and large. As you all know, depositions, criminal depositions can't be used as they can in civil cases as a substitute for the witness appearing. There's a confrontation issue, and the criminal depositions, unless it's a deposition to perpetuate testimony done in accordance with the rules, cannot be used except for impeachment or refreshing recollection. Now, that doesn't mean you don't use objections in a deposition. It is a good practice, I believe, to clarify if something is ambiguous or there's a compound question or it's vague. It's always good to let for a prosecutor, if it's a defense deposition, to let the defense attorney know so that it can be clarified in the deposition at that point. And that would be the context of a use of objections. It's not for the purpose of that deposition in toto coming into the trial itself or the hearing. And now if a witness refuses to answer a question, and sometimes there are belligerent witnesses, and Lord knows the state of Florida doesn't have any control over the witnesses, defense attorneys don't either. If there is a witness that refuses to answer a question, my recommendation, and you can do this, is to certify the question so the court can be made aware in a motion to compel or for protection at a later date if it becomes a critical question. Rather than to bog down and to start arguing in the middle of a deposition, best practice is to move on, try to get as much of it done as possible. Now, additional practical applications in depositions. The attorney can move for a protective order with the court, 3.2201 L1, limit the scope, seal, or prevent the deposition to protect a witness from harassment, unnecessary inconvenience, or invasion of privacy. Now, a motion to terminate the deposition. If a deposition goes off the rails, and number one, anything that is not verbal or anything that is not captured in a verbal exchange needs to be made a part of the record. What do I mean by that? If an attorney becomes aggressive, if an attorney stands up, points a finger at the witness in a deposition, raises their voice to the witness in a deposition, unless it's a video deposition of a child or a sensitive deposition, it's not going to be part of the record. So that needs to be made a part of the record. How do you do that? Let the record reflect. The defense attorney has stood up, is leaning over the victim, pointing his finger at the victim's chest, and screaming at the victim at this time. Why do you do that? Because if a deposition goes off the rails like that, you can stop the deposition. I would recommend that you try to work it out, but then you can stop and move for a protective order if you're a prosecutor, or if you're a defense attorney and it's one of your witnesses for that matter. And then it may be the one bite at the apple. Although constitutionally, the deposition will probably resume if it's a material witness. But the court can be made aware, and the witness can be protected from harassment. Now, one other thing, a defense attorney cannot create evidence. A defense attorney cannot create a photo lineup, 3 photo lineups with 3 cousins of the defendant, and then put it in front of a victim in a deposition and try to get them to misidentify. That doesn't work. Well, it's not in accordance with case law. Kuntzman v. State, 3rd DCA case, 1994. Can't create evidence. If you have a picture of the scene, yes, indeed, if you have an agreement with the state and the defense that, and the witness can testify that that's fair and accurate, that's a different situation. Obviously, it's by agreement, it's not by ambush. Do not tell a witness that he or she cannot talk to the defense or suggest that they withhold material information or any information. Basically, a witness is free to speak to, and to say anything to anyone they choose. And that's Rule 3.220I. It's also a Florida bar rule. You can't insert yourself and instruct witnesses to withhold information. 4-3.4A and F. Interrogatories are a civil creature. They're not permitted in a criminal case. I would submit if you have an agreement, that's one thing, but over the objection of defense, you can't use interrogatories, nor can the defense ask the judge to allow interrogatories of a defense witness. And Moore versus State is a case that specifically says that, and the case was reversed because the deposition was not allowed to go forward and interrogatories were used over the defense objection. Now, defense subpoenaed Ducas Tecum as of January 1st, 2016. Defense subpoenas Ducas Tecum are permitted. Previously, they were not. Only the prosecutor could issue a subpoena. But in this instance, Rule 3.220H1. Now, there are some requirements. Number one, following the civil rules, Civil Rule 1.351B requires 10 days notice to the other party, the opposing party, before service of the subpoena, including specific items to be produced. Now, Civil Rule 1.351D allows the opposing party to object and file a motion with the court. Now remember, Marcy's Law is going to impact this. Marcy's Law is constitutional for a defense attorney to issue a subpoena Ducas Tecum to a victim for victim information or information about a victim. That's going to be played out in the courts. And of course, Constitution does trump a statutory enactment. There is a movement afoot. I know it was introduced in rules last year that to expand this to allow defense to issue a subpoena Ducas Tecum without notifying the state. There are problems with that, not only Marcy's Law, but criminal cases are unlike civil cases. Everybody in a criminal case, arguably, is dragged in because the crime is not something that anybody either anticipated or anybody has a stake in as a victim or witnesses. There are ways to get the judge to go in camera or ex parte and to explain to the judge, I do not want the state to be aware of what I am doing in this case. Fine. That is permitted by the rules. So there really is no reason to expand this to do a subpoena Ducas Tecum without notice, so that at least the state has a chance to for a protective order and to bring it into court. And the defense does have a way of going before the court ex parte without alerting the state to the fact that they're seeking certain information. Now, a motion for protective order is the proper way to object to a subpoena Ducas Tecum. That's under Civil Rules 1.351D. Should be in the form of a protective order. If the release of the information will invade the privacy of a victim, that's constitutional now, or a witness, And I put some examples down here. By the way, I have a lot of words in this PowerPoint. I violated every PowerPoint rule known to professional life. And I do that because this PowerPoint will help you if you need to refer to anything and you don't have a photographic memory, you can remember everything I say. And you have this as a reference. It's kind of an outline and a go-by. But anyway, you know, there are certain things, Facebook posts, personal things, you know, oppressing a witness. How about 10 years of business records? You know, bank records. Obviously, health, you know, medical records are a different animal as well. But the protective order will allow the court to examine as to whether this is a fishing expedition or this is a legitimate discovery tool. Rule 3.220F, this has been there for a while. It's the reason why the defense can go to the court at any time, ex parte as well, to try to require such other discovery as justice requires. Now, the defendants, the case law that exists is prior to 2016 that I've got here about eliminating fishing expeditions at the expense of witnesses or harassment or oppressiveness at the expense of a witness or a victim. And so basically it just says when a court is examining a request, whether it's ex parte or just a motion because the defense doesn't care whether the state knows about their attempt to get this information. At least the court can make a finding. Is this material, or is this just is this calculated to lead to admissible evidence, or is this just a fishing expedition that's meant to harass? And so here's some cases that deal with that issue. Now, sanctions, Rule 3.220N, failure to comply with an applicable discovery rule or order is subject to a motion to compel and order. Sanctions include striking a witness, mistrial, introduction of otherwise inadmissible evidence. Prosecutors, try striking a witness, a defense witness. That's not going to happen. Continuance, that'll happen. But it's not a question of whether the playing field is level, because the argument on both sides, the state is bringing charges against a person. And so the state has obligations, not only to prove it beyond a reasonable doubt, but also to make sure that the trial is fair and that the information is not an ambush. And that's why there are so many obligations on the state as opposed to the defense. Willful failure to comply with a discovery rule or discovery order subjects counsel to sanctions, including contempt or costs. That's rare. It really has to be some gamesmanship for that to have to come into play. I would ask defense attorneys, I would hope that defense attorneys would not just dangle sanctions and contempt against prosecutors for doing their job or making an honest error that is corrected. A request for discovery or response must be signed by the attorney of record, defense and state, which constitutes a certification that the signer has read the request, response, or objection, and it is consistent with the rules, not done to harass, cause delay, or additional cost of litigation, and is not unreasonable or burdensome. You got to, prosecutors, defense attorneys, you've got to read your discovery documents. You can't have staff fill it out for you or just put it in there. You have to make sure you're aware of what you're giving out, and you're certifying that you've read the request, response, or the objection. The defense objection in a discovery violation. Prosecutors always, always, always ask for a Richardson hearing. The Brown versus State case could have been rectified at the trial level. Instead, the case was reversed. It blows your mind, because there's a little bit of gamesmanship going on here, but hey, the rules are what the rules are. The state had multiple cases where a video was applicable to multiple cases. It forgot or neglected to submit that in the discovery exhibit, the video in one of the cases. That case went to trial. The trial starts. The state's going into the video. The defense objects, and the court says, well, you know about the video. You represent him on all the cases. That's not the point. The appellate court found that, hey, the opening statement might have been different. The theory of defense might have been different. You need to follow the rules, and you need to, any evidence that you plan on using in any particular trial has to be included in discovery. If there had been a Richardson hearing, the court could have determined whether it was trivial, whether it was substantial, whether it was intentional, whether it was inadvertent, and whether it prejudiced the defense. But that never happened because the court did not do a Richardson hearing. So even if it's a no-brainer in your mind, prosecutors ask for a Richardson hearing. Discovery schedules, this is kind of skewed a little bit with regard, and we'll talk about this with Marcy's Law. The trial court may hold a pretrial conference to consider such matters as will promote a fair and expeditious trial. The court may set, and upon the request of any party, shall set a discovery schedule, including a discovery cutoff date at the pretrial conference. There's no reason why a case should be 2 years old. There's no reason why a DUI should be 2 years old in county court. If it appears that defense is not taking depositions, not doing their due diligence in discovery, ask for a discovery pretrial conference. At least you'll get cutoff dates, and the court will be mindful that this case is going on and on and on. Now, again, application of Marcy's Law, Article 1, Section 16b5. This is huge when it comes to discovery. Huge, huge, huge. The right to prevent the disclosure of information or records that could be used to locate or harass the victim or the victim's family, or which could disclose confidential or privileged information of the victim. If the victim requests, our discovery will redact information, location information. Now, if that butts up against defense, the constitutional rights of a defendant, that's going to trump Marcy's Law, that part of the Constitution. But there will be litigation. Well, I predict there will be litigation because once requested, that affects discovery all the way down the line as far as the victim is concerned. So keep that in mind. It's coming down the pike. Article 1, Section 16b10, again, Marcy's Law, the right to proceedings free from unreasonable delay. What does that do to the discovery, the discovery conferences? Well, the same type of rights. I mean, within 5 days, within 30 days. Unless the rights of the defendant are implicated, this case is speeding the trial. This is going to trial, and the judges have to look at that constitutional provision, and they have to give due deference. In the old days, the right to speedy trial was we had to object, meaning prosecutors had to object 3 times to a continuance and then demand speedy trial, and then the defense still could come forward and say, I'm not done, I have more to do, and try to convince the court. So again, these Marcy's Law sections are going to impact discovery, and they're going to impact the right to a speedy trial. Florida Criminal Rule of Procedure 3.220b4, prosecutor has an ongoing obligation, and now we're getting into exculpatory evidence. And just broadly, there are 3 different aspects. One is by the rules. Another is constitutional, which is Brady, Giglio. Giglio is not necessary. Well, it is grouped in because it's false statements known to the prosecutor. And 3, there are ethical rules that apply specifically to prosecutors. And we religiously guard those ethical rules because we need to be above reproach. We as prosecutors need to be professional and ethical in everything we do. So the rule, a prosecutor has an ongoing obligation under the rules of criminal procedure to disclose as soon as practicable after the filing of the charging document, which that's a little different from Brady, as soon as practical, Material information, that's the same as Brady. Material information that tends to negate the guilt of a defendant. Okay, now one question that arises, does the rule apply to impeachment? Because Brady does, we'll talk about that later. Does the rule apply to impeachment? I'm not aware of any case law on that. If it does apply to impeachment, what does that do to pleading cases out? And we'll discuss that a little bit later on when we're talking about Brady and the Supreme Court of the United States and whether that information needs to be disclosed prior to a plea. Now, does the prosecutor have an obligation to turn over impeachment information as soon as practicable? And again, before a plea. Again, we'll talk about the Ruiz case, Supreme Court, U.S. Supreme Court case. We'll also talk about the American Bar Association formal opinion 09454, which talks about the special rules 3.8 that apply to prosecutors, which go beyond, ethically go beyond the rule and Brady. Now, let's talk about Brady. I want to start by saying Brady is not a discovery violation. Brady is an appellate issue. If exculpatory information is withheld before the trial, it's a discovery violation, not a Brady violation. And people bandy Brady around, but technically speaking, there's no jury finding that there's a reasonable probability that it would have been different. So, getting on to the Brady obligation, materiality. The rule says material evidence. Brady says material evidence. Brady is constitutional. Rule is statutory court rule. The suppression of by the prosecution of evidence favorable to an accused upon request violates due process, where the evidence is material either to guilt or punishment, material, irrespective of the good or bad faith of the prosecutor. Irrespective of the good or bad faith. I didn't know. Brady violation is irrespective of good or bad faith. There are three prongs to both Brady and to Giglio, the three prongs of Brady. The evidence must be favorable to the accused, either exculpatory or impeachment. The evidence must have been suppressed by the state, either willfully or unintentionally, and there must be prejudice. Okay, those are the three prongs. Now, evidence is material for Brady purposes only if there's a reasonable probability that had the evidence been disclosed to the defense, the result of the proceeding would have been different. A reasonable probability, according to U.S. v. Bagley, that's a U.S. Supreme Court case, reasonable probability is a probability sufficient to undermine the confidence in the outcome. Now, talking about prejudice and materiality, because that's where the rubber meets the road in terms of the case law. Generally, that's where the battles are fought, and that's where I'm going to give you at least some guidelines and ideas as to where that threshold lies. Prejudice is measured by determining whether the favorable evidence could reasonably be taken to put the whole case in a different light as to undermine confidence in the verdict. Now, Wright v. State, the court found that there was no duty, in other words, it was not material, to disclose the criminal history of another possible suspect, and neighborhood complaints about that suspect, and police reports involving other known criminals in the neighborhood. Okay, that didn't rise to a material exculpatory information. It could be exculpatory, it could be admissible, maybe it's not, but it doesn't rise to that materiality level. There's something called the cumulative materiality analysis. Now, various courts, and I'm starting with the U.S. Supreme Court, the court must conduct a cumulative materiality analysis to evaluate the tendency and force of undisclosed evidence, item by item, before separately evaluating its cumulative effect. One piece of evidence that's withheld might not rise to the level of materiality. but 5 taken together could result in the jury looking at the case in a whole different light, and there being a reasonable probability that the jury verdict would have been different or it would have made a difference. Now, in making the determination, the court can't simply discount, and this is an important part of the analysis, the court can't discount the inculpatory evidence. Now, I'll be talking throughout Brady when it comes to materiality. Courts make their determination and they take into consideration the strength of the state's case. Because the stronger the state's case is, the more evidence there is, the less likely withheld evidence would rise to the level of materiality within that case. So you're going to see a lot of reversals that kind of seem counterintuitive, okay? But the case itself, the facts of those cases, the state case, they're thin. And the thinner the evidence is to convict, the greater the materiality of the withheld exculpatory evidence. So Jimenez versus State, there were 81 pages of undisclosed handwritten notes. The defense was already aware. Prong 1 was kind of not really violated because the contents of those notes weren't released, but the knowledge of what was in them in terms of the evidence itself was known to the defense attorney. It wasn't anything new. Smith versus State, adding up the force of the undisclosed evidence and weighing it against the totality of the evidence introduced at trial. In other words, the stronger, as I said, the stronger the state's case, the less prejudicial the effect of the undisclosed exculpatory evidence. Now, the inverse is true. In Denton versus State, that's a 4th DCA case just last year. It reversed a conviction where the state did not disclose independent DNA lab test that showed the victim as the major contributor with an unknown minor contributor. Now, there's a case that goes opposite that, but the court noted that the state had ample evidence other than this DNA test. But in the Denton case, all the state had was a fingerprint in the wrong place, and the fact that a witness said, "Hey, the defendant's been in the area a few times." So when the court looks at that as the totality of the state's evidence, and then looks at the fact that the DNA report was not, even though the defense was aware that there was DNA, when the DNA report is not given out, that there's an unknown minor contributor, that was enough to tip the scales and reverse the case. So be careful. I mean, this was the court said that the state should have known and should have let this information out. This happened in the 15th Circuit. I know the case. As case law, the record wasn't adequately protected. It really didn't go down as the record reflected. Our prosecutors in the 15th Judicial Circuit are trained and trained and trained again about exculpatory evidence and the need to disclose. When in doubt, give it out. So let's talk about this. I call it splitting hairs because it's a pun. This both involved forensic evidence of hair analysis. In the one case, Hoffman versus State, the state is required to disclose the results of a hair analysis where the test results excluded the defendant and the victim, thereby implicated a third unknown person. Mere general disclosure of the existence of the analysis without results is not sufficient. The state has a duty not just to tell a defense attorney, because there is a due diligence requirement, and we'll talk about that. Defense can't just stick their head in the sand, but when you have a report, you've got to give that report and you've got to give the results of the report. The defense is not obligated to make continuing inquiry. If they ask for it, give it to them. Give it to them without them asking for it. Now, Hoffman, the court noted that the evidence supporting the conviction was thin. Now let's go talk about Rhodes versus State, another Supreme Court case 7 years later. No Brady violation where the victim was identified as the source of the DNA on most of the hair samples, and findings were inconclusive as to the defendant as to the possible source. Inconclusive results were found not to be exculpatory. Well, Rhodes distinguishes Hoffman, but also notes that the state's case, the state had ample evidence. The state it wasn't a thin case in terms of the evidence presented. Now let's talk again about Parker versus State, which is just giving you examples of how the court comes out on these things. In Parker, the court noted the sufficiency of the evidence to overcome any prejudice. In other words, the analysis, the materiality analysis, the more the state's evidence, the less prejudice a piece of evidence is that's not disclosed. So the fact that the state withheld impeaching information regarding the terms of a cooperation agreement by disclosing that the witness was to testify truthfully in a death penalty sentencing, where the actual agreement required that he testify truthfully in accordance with his prior testimony and statement made to the police. Let me tell you, that's not a Brady violation. If the prosecutor knows about that, the prosecutor needs to correct that statement. The Giglio issue was not preserved. We can talk about Giglio. It's a much higher standard on the state, and it should be, because it's a matter of false statements known to the prosecutor. This is an omission that in a Giglio context would probably be material, depending on how much evidence and how much impeachment was out there that might tilt the scales. But it wasn't preserved, so we'll never know about the Giglio issue. Again, the court noted the overwhelming evidence, or at least the sufficiency of the evidence to overcome any prejudice in that regard. But prosecutors, if you know a defendant is not giving the complete information, correct it during the testimony. It's easy to do, it's the right thing to do. Mere possibilities of an item of undisclosed information that it might be helpful to the defense or might have affected the outcome does not establish materiality in a constitutional sense. United States versus Augers, a U.S. Supreme Court case in 1976, mere possibilities, speculation, that's not going to win the day on a Brady issue. Now, Boyd versus State, Florida Supreme Court case, a list of potential print matches with no actual match. The court found that was not a Brady violation, and also noted, again, there was a substantial amount of other evidence supporting the conviction. That might have gone the other way if it was a he said, she said with no forensic. We'll never know, because the court makes that materiality analysis. Each case is different, but it begs the question. If you're having a discussion with yourself, now, inadvertent failures to disclose, there's nothing one can do about that. If the police know something, we'll talk about that. It's imputed to the prosecutor. That's inadvertent, that's unintentional. But if the prosecutor knows of evidence that could be exculpatory and has, well, is this Brady or is this not Brady? If you're asking yourself that question, you've already answered the question. You've got to release that. If it's inadmissible, we'll talk about inadmissible evidence not being Brady as a matter of definition, because it can't affect the outcome because it's inadmissible. But don't make the determination that because you find that, it's not going to go in, that you don't give it out. Make the argument in a motion in limine, but you got to give out that information. And ethically, the ABA opinion says that you do as well. Don't make the determination of whether it's admissible or not. Just when in doubt, give it out. Now, State v. Morrison, Florida Supreme Court case 2 years ago, the ultimate conclusion that the evidence of an unused condom in the victim's pocket supported this is the defense theory. So the defense theory was that the victim planned to have sex with the witness's girlfriend, and the witness got mad, and the witness killed the victim and not the defendant. And the court called that rank speculation. It's a theory, but there's nothing to indicate that was a theory of anything else but speculation. And so that does not rise to the level of prejudice. That's not even, it could be determined that it's not even exculpatory at all, because it's a kooky theory, according to the court. The Brady burden is on the defense. We'll talk about it. It's a lot different with regard to Giglio, but the burden is on the defense to show prejudice. The prosecution is not required to provide the defendant all information. This is Carroll versus State, Florida Supreme Court 2002 case. To provide the defendant all information regardless of its regarding its investigatory work on a particular case, regardless of its relevance or materiality. Okay, it's not a gotcha thing. If it does have exculpatory value, it should be released. But fishing expeditions, I mean, all the investigative notes, not so unless it's material. Now, these investigative notes indicated that a stepfather of a victim may have been an abuser and a possible suspect at one time. And the state says in a Brady context, this is not required to be released. You know, if you're aware of it and you're aware that another suspect was developed, why not release it? If it does become relevant and it comes in, you know, do you really want the case, if your case is thin, to be reversed? Plus the fact you have ethical obligations as prosecutors as well. I'll give you a little heads up on that. You should already be aware, because you all are aware of the prosecutor's duties that are separate and apart from everyone else. We have our special ethical obligations. And one is to supply exculpatory evidence that tends to negate, not necessarily material, but if it tends to negate the guilt of a defendant, the ethical obligation, which doesn't affect the case, but it's our duty, should be followed. So again, when in doubt, give it out. All Brady, potential Brady violations, whether they are or not, should be inadvertent. They shouldn't be calculated. And again, you know, that's an ethical obligation, and we're talking Brady, which is your constitutional obligation. And in Carroll versus State, those notes ain't coming in on a Brady analysis. Now, the court made a finding of no prejudice based on the quantity, again, the quantity of evidence against the defendant in the context of the entire record. A materiality analysis, which they're required to do. Lord knows, if your case is, the more thin your case is, the more you have to, you know, on a Brady issue evaluation, you have to disclose anything that remotely could be exculpatory. The next two slides illustrate just how tricky a materiality analysis can be in terms of impeachment evidence. Now, you know, always consider, when in doubt, give it out, because this is a world of hurt on these next two cases that didn't need to happen. In Darren versus State, a 4th DCA case, the state withheld a letter detailing a bouncer's workers' compensation award of $24,000. Now, here's the rub on that one. If the bouncer is the aggressor in the fight that happened at this bar, then the bouncer would not be entitled to workers' comp. So there's a motive, there's a financial motive. Now, I venture to say that either the prosecutor in this case didn't realize that the letter was significant in terms of impeachment, or didn't even see it. But always know this, if there's a crimes compensation trust fund award, for example, same thing. There's a motive here, because if the victim is the aggressor, they're not entitled to the award. So again, there should be no debate. When in doubt, give it out. And Guzman takes that cumulative impeachment angle to the analysis, the materiality analysis. But Guzman lasted 10 years, and it went up and down. Guzman involved a witness who received $500 reward. And the witness withheld that in their testimony. The state was aware, the detective was aware, and they did nothing. So classically, that would be a Giglio violation, which we'll discuss later. But in this case, it was ruled on in the trial court as a Brady issue. And the trial court said, no, there's cumulative impeachment, there's so much impeachment and so much corroborative evidence that it's not a Brady violation. Well, it went to the 4th DCA, and the 4th DCA agreed, no Brady violation, but sent it back to the trial court to make a determination as to whether there was a Giglio violation, which is much more defense-friendly. And again, we'll discuss that later. The state has to show beyond a reasonable doubt that this lie or this misstatement that the prosecutor was aware of and didn't correct was material or could have, if there was a reasonable doubt that it could have affected the outcome as opposed to a probability that it did. So what happened was it was sent back to the trial court. Trial court made a Giglio determination and sent it, and it was appealed back to the 4th DCA and then to the Supreme Court. And the Florida courts determined there wasn't a Giglio violation either. Guess what happened? Win the battle, lose the war. It went on a habeas to a federal court, and the habeas was granted, and it was referred back to either dismiss or to have a trial within 90 days. You never want that to happen. Clearly, if there's a promise made or a reward given, and you know about it, Giglio demands that you disclose that if the witness does not, that you correct false testimony. We'll talk about that in great length later. Any knowledge in the possession of law enforcement is imputed to the prosecution. They're not. There's no bad faith, but Brady applies irrespective of the good and bad faith of a prosecutor. Now, let's talk about evidence not in the state's possession. There's no Brady violation where the alleged suppressed evidence is not in the possession of the state. That makes sense. We don't have it. Now, Gomez versus State is a U visa. The state did not have possession or control. There was no obligation to go out and get the document, which was available to both sides by subpoena. Now, the defense was aware of the U visa information. It wasn't like the state had knowledge of that and withheld it from the defense. But the state was not obligated to go out and get the application and get all that information. Harrigan versus State, a 3rd DCA case, 2016. The video of the original theft. This is an interesting case because a car was stolen in an adjoining county 3 days earlier. And there's a video of the people who stole the car. And it wasn't the defendant. Defendant is caught fleeing the police with a punch steering wheel 3 days later in another county. And the theory of the state's case is he should have known it was stolen. He knew because it was punched. It was recently stolen, 3 days, well, not so much. But there was no issue of the defendant originally stealing the car, okay? The theft video was found to be not material on that basis because it wasn't even part, it was also not exculpatory as well because it didn't have anything to do with the state's theory of the case. Reasonable diligence. The defendant has a reasonable due diligence requirement of obtaining information that the defendant can obtain. Okay, now, notwithstanding if you have an expert report or a DNA report, turn it over, obviously, with the report as well. But the defendant can't, defense attorney can't put his head in the sand and just say, hey, you know, I know it's out there, but I'm just not going to ask for it. So Floyd versus State, defendant knew about a taped interview, that it existed, but failed to order it from the police agency. Tompkins versus State, another Florida Supreme Court case. There was no suppression under Brady where the defense was given an illegible copy of a police report because the defense knew about the report, could have requested a legible copy. When it went through the copier, it skewed some of the report that the state turned over. Provenzano versus State, there's no Brady violation where the defendant either had or could have obtained his jail records from jail officials and could have reviewed the notes of the state expert witness if he had requested them. guarantee you these were solid cases that the state prosecuted. They weren't thin cases that relied on a fingerprint or a witness. Because the analysis can be different, as we were talking about. The more the state has, the less the prejudicial effect of a withheld piece of evidence. Now, Brady prong 2, I'll tell you what, we're going to take a break right now, and we're going to come back and do the second half of this. We'll start on prong 2 of Brady. We'll get to Giglio. We'll talk about internal affairs investigations, and then I'll let you go. So take a few, and we'll see you in a minute. Well, welcome back to part 2 of Brady, Giglio, and Discovery 3.220. Now, let's talk for a minute about Brady, the prong 2 of Brady, which is, did the state actually suppress the evidence, either inadvertently or intentionally? The defendant's knowledge of allegedly suppressed evidence will defeat a Brady claim. Jimenez versus State, last year, Florida Supreme Court, and I had mentioned that earlier, 81 pages of handwritten notes covering information that was already known to the defendant. So it really wasn't a suppression of evidence. Didn't even get to prong 3 as to materiality, although the court did say it wasn't material either. The knowledge of the defendant, again, will defeat a Brady claim. A Brady claim can't stand if a defendant knew of the evidence allegedly withheld or had possession of it simply because the evidence cannot be found to have been withheld. Floyd versus State, it encompasses the due diligence requirement, easy for me to say, into the second prong. If the defendant knows of the existence of the evidence and has access to the evidence, it's not withheld within the meaning of Brady. Wickham versus State, Florida Supreme Court case 2013, prior convictions of the co-defendant. Maharaj versus State, it's Florida 2000. Now beware, win the battle, lose the war. As prosecutors, any Brady violation should be inadvertent. Period, the end. Period, the end. Okay? So again, if you're having a discussion with yourself, or you recognize something as potentially exculpatory, when in doubt, give it out. Here, there could be a 3.850 ineffective assistance of counsel argument if a defense attorney doesn't do their own due diligence. So just keep that in mind. In the long run, you want to make sure the record is protected, and you want to make sure the defendant gets a fair trial to boot. A prosecutor's duty is not just to convict, but to do justice in every case. A duty to disclose a prior record of a victim or witness. This is hotly contended in every circuit in the state of Florida. Any prosecutor who has been prosecuting for any length of time has had this come up multiple times. What are the requirements under Brady for the disclosure of potentially impeaching information in terms of prior records? Well, in State versus Crawford, State versus Conley, two Florida Supreme Court cases from 40 years ago, the state is understand that the state is prohibited by contract and by law from disseminating CJIS information. We can't give an NCIC to a defense attorney. We can't allow a defense attorney to look over our shoulder. That would be a violation of the CJIS rules and potentially a violation of law. So what is the state required to do? Well, we are required to produce a summary of convictions upon demand and with a court order of a criminal record of a defendant, a co-defendant, and potential witnesses in our possession. Now, of course, a defendant, you're going to let the defense know what convictions you have, because if you go to trial, you're going to have to use those to impeach, or you may potentially if the defendant testifies, or through other means if his statements come in through a third party. So obviously, defendants' prior convictions are going to come in. Now, what about potential witnesses and co-defendants? Well, if you got them, you should give a summary out. If you don't have them, you don't have them. And you're not required to go out and get them. Here's State versus Wright, 4th DCA case 2001. We find no authority within the criminal discovery rules that requires the state to disclose the criminal histories of all listed witnesses, including those who will not be called to testify. Okay, so, we have a little bit of tension here. By court order, you're going to release them. But if they're not in your possession, okay, here's Hansborough versus State, Florida Supreme Court case, 1987, also State versus Wright. The state has no duty to actively assist the defense in investigating its case. The defense has the initial burden of trying to discover impeachment evidence, and the state is not required to prepare the defendant's case. This is especially true when the evidence is equally accessible to the defense as to the state. The defense can get the prior records, but there may be something out of state that the state may have or have access to. If you actually have this evidence and it is impeachment evidence, if it's requested by the defense, it's not a hill to die on, for sure. But know this, the defense has some due diligence requirements, not to just sit on their hands and have the prosecutor do all their investigating for them. Let's talk about oral statements, which are non-exculpatory. Remember, an oral exculpatory statement is Brady. If somebody makes we're going to talk about some cases out there where if a victim recants, oh, it's not taped. No. Absolute obligation if you have oral testimony by rule and by Brady that conflicts with the statement of the witness in a previous time. Or if it's the only statement you got, but it's oral and exculpatory. Neither side is required to alert the opposing party to the content of a witness's testimony, except to the extent a written or recorded oral statement of the witness or an expert witness report may foreshadow what he or she will say on the stand, okay? So you're not obligated unless it's exculpatory, okay? Change in testimony, you are absolutely obligated because that's impeachment. Non-exculpatory unrecorded oral statements made by a witness are all they are your meetings with the witness and your prep for trial. But if those statements materially differ, then from the written or recorded statements previously given, they must be disclosed. That's Elgo Mari versus State, the 4th DCA case, 2011. But it's common sense. That's impeachment at the very least. And if it's talking about substantive evidence, it's even worse. I did it, I didn't do it, he did it, he didn't do it, I saw him, I didn't see him, he was wearing white, he was wearing blue. That stuff is important, and obviously every prosecutor knows the obligations to disclose that information. I'm going to talk about a case out of the 15th Circuit, sorry. Smith versus State. Illustrates a couple of the issues that we've been talking about. We have a prosecutor who's got a sex crimes case. We have a now adult victim who is the victim in the case, and it's ongoing. And victim calls up the prosecutor, says, I'm tired of all this. It didn't happen. Wait, what? The state prosecutor brought in the witness, had a conference with the witness, did a couple of things wrong. Number one, didn't have anybody in there with the prosecutor as a witness, as will happen. And this is actually exculpatory, and it's also inculpatory in a way, double-edged sword, because once the victim came in, the victim said, look, I'm getting pressure from my family, I'm getting pressure. Of course it happened. Everything I said was the truth, but I just wanted to go away, so that's why I said what I said. That information was not disclosed because it was immediate. The meeting happened like an hour later in the prosecutor's office, but it was exculpatory and it needed to be handed out. Now, a new prosecutor took over the case. Case was still in discovery, in the discovery process. And the prosecutor looked at the notes and said, oh, release that information to the defense. What do you think the defense did? They said, Brady violation. Well, was it a Brady violation? Trial hadn't happened yet. No, it was a discovery violation, not a Brady violation. It did involve exculpatory evidence, but the rules of procedure, criminal rules of procedure, talk about the obligation to give over material exculpatory information. It's the same as Brady. It's just the rule instead of the constitutional due process. Brady doesn't come into play till after the trial, till the jury makes a decision. So what happens? Well, they list the prosecutor as a witness who has since left the office and working for a different organization. What happens? State does a motion for protective order. What happens with the motion for protective order? Well, the court grants it because it's a prosecutor. And the case gets reversed on the grounds that the prosecutor should have been a witness in the case. There was nobody else in the room. So interesting case. Things get out of hand sometimes. The prosecutor is an excellent prosecutor, by the way. Got away. And you know what? There was no harm to the defendant because all became known. And as I said, it's a double-edged sword when the victim says, yeah, I was pressured, and that's why I recanted for that 45 minutes before I said, no, it really did happen. So what about a victim recommendation? Let's talk about, where does that exculpatory evidence rise to the level of needing to be released? Okay? Does there come a point when a victim recommendation itself becomes impeachable or exculpatory? I know in the 15th Circuit, we send out a victim impact statement. We want to know, in writing from the victim, we ask certain questions. It's just a pro forma thing. What are your recommendations? Is the fact that a victim recommends jail, is that exculpatory? Is that admissible? Is that impeachment? That's going to be an argument back and forth. If it's a run-of-the-mill, I'm saying no, but hey, when in doubt, give it out, ethically for sure. But if a victim tells a prosecutor, I want this son of a gun to rot in jail. I ate him, he ruined my life. You're getting to the tipping point where there's a motive and a bias on the point of the victim. Now, again, double-edged sword. Is it admissible? Probably is. You stated in your victim impact statement you wanted him to rot in hell. But then the victim gets to say, why do you want him to rot in hell? Because he ruined my life. Stuff that might not be admissible because it would be overly prejudiced. This is the things that he did to my life. So again, when you're making those calculations, and you shouldn't make the calculation based on help or hurt, but you need to think about Brady. You need to think about material exculpatory evidence when a victim flies off the rails, and especially in writing, talks about how hurt they are by the case. Plea bargains. Brady applies to substantive evidence. You cannot plea bargain a case if you have material exculpatory evidence that you have not released, because when the defense finds out about it and they want to, they can come back and get the judge to withdraw their plea. Taylor versus State, first DCA case. The facts are the state failed to reveal a blood test and witness testimony that the other driver in a DUI manslaughter was intoxicated, driving erratically and talking on the cell phone at the time of the crash. Think there's an issue with causality there on the DUI manslaughter? That's substantive evidence. That has to be turned over. It's material substantive evidence that needs to be turned over. Now, what about impeachment evidence? Does impeachment evidence have to be turned over prior to a plea? Not according to Brady. Not according to the Supreme Court of the United States in U.S. versus Ruiz, 2002. You want cases to plea. If it's merely impeachment, we're telling you, go ahead with your plea. You don't have to turn it over. You know, if it, according to the rules, because you turn it over as soon as practicable, if a prosecutor is aware of impeaching information, it should already be in the hands of the defense before the plea. The ethical bar rules, although it's the ABA opinion, and it's based on the ABA's view of a fact pattern that's pretty egregious. We'll talk about that in a little bit. But it says if it tends to negate, and in the ABA opinion 09-454, and I encourage everybody to read that ABA opinion. You know, we haven't had a court case and we haven't had the Florida Bar chime in on this. This is an advisory opinion, but they disagree in that opinion with Ruiz and say that prosecutor has to turn over impeaching information that tends to negate the guilt. You know, it's an issue and you need to be aware of the issue. Most of the time, impeaching information comes later. You know, it'll come, and if it had come earlier, it would have been released in discovery in the first go-round. But got to be mindful. But Brady, for Brady purposes, impeachment information, no matter how bad it is not considered, is not a bar, and will not reverse a plea or allow a defendant to withdraw a plea. Let's talk about a recantation versus an affidavit of no prosecution. I got to tell you, Randall is one of those issues where you look at a totality of the circumstances and the evidence. You look at a materiality evaluation. Randall, I guarantee you, that was a thin case. That was a he said, she said case. Defendant was found to be entitled to a hearing on a motion to withdraw his plea after learning that an affidavit by the victim, his girlfriend, filed with the state attorney's office stated her desire to drop the case, and it was not disclosed. How is an affidavit that I don't want to prosecute admissible? How is that admissible? It doesn't have anything to do with the facts of the case. It's not a motive. It's actually a motive for her to testify favorably for the defendant. She doesn't want to prosecute the case. But the court said, quote, "It is reasonable to assume that knowledge of the alleged victim's actions would have been useful to Randall at trial." How? Well, okay, it doesn't matter because they looked at this from a materiality analysis and determined that it was a very thin case, and that's the first DCA case, and it's out there. So again, think about your no prosecution affidavits. Defense is usually aware of it because I got to tell you, defense usually talks to the victim, and the victim says, "I don't want to prosecute," and they're the driving force behind the victim coming in and saying that in terms of process. Nothing illegal or wrong with that as long as there's no coercion or suggestion that is untoward. But you know, in this particular instance, it doesn't say it and by the way, case disappeared, so we don't know what the facts are beyond what happened to the case. Probably was either null prost or a pretrial disposition. Okay, plea bargain, deceased witnesses, deceased or unavailable witnesses. Brady? How, you know, it's like an affidavit of no prosecution. How is that admissible? You know, how is that, well, actually, how does that change, better yet, how does that change the facts of the case? The fact that you have a victim or a witness that is in Tangiers and says, "I'm not coming back," you plea out the case, but how does that change the facts of the case? It's different if the victim or witness calls up and says, "it never happened," or "I lied," you know, or whatever. That's different. That's substantive information. That's exculpatory. But the mere absence of a victim or a witness the unavailability is not a substantive issue, and it should not impact a plea. Now, I got to tell you, every time we interview a prospective lawyer for the 15th Judicial Circuit, we'll ask something along the lines of, you know, number one, can you plead the case? And number two, if the defense asks you, do you have your victim or do you have your witness, material witness? You're obviously going to say the truth, you know, but you're not required to let them know that your witness is unavailable at the time. Brady is an appellate issue. I talked about this earlier. It's common sense. There's no violation unless there's an outcome at trial, because there's no outcome to be affected. There's no jury to be affected. Similarly, if the information was discovered by the police or the prosecution after trial, Brady does not apply. The proper vehicle would be a 3.850, newly discovered evidence. I say this, when in doubt, give it out. Don't die on that hill. You know, if you have a great case, you know, hey, hit me with your best shot. As a prosecutor, again, we live in Florida where we have ethical obligations and we have duties, open discovery duties, we have Brady obligations, and we shouldn't be having those internal arguments with ourselves as to whether or not to release. If you're having that discussion, you've already answered your question. Again, you know, I said I'd be talking about the Florida Bar Rule 4-3.8, special responsibilities of a prosecutor. We're the only lawyers that have a special responsibility because we have unique power in the annals of lawyers. We are prosecutors. We're supposed to wear the white hat, do the right thing at all times. The prosecutor in a criminal case shall make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate, again, that goes along with the rules, tends to negate, and Brady, the guilt of an accused or mitigates the offense. Wait a minute. Doesn't say materiality. It doesn't say material evidence. Ethically, this doesn't affect your cases. This is not going to result in a reversal. This is not going to result in a person being able to withdraw a plea. This is ethical, which is why you need to give it out when in doubt. When in doubt, give it out. Same thing. And I encourage everybody, I'll go back to this, encourage everybody to read ABA Formal Opinion 09454. To the extent that it's adopted in Florida is a question because I've never seen any action under this. But again, we're pretty good in Florida at discovery. I mean, we've been doing this for a while. And we know our ethical obligations and our duties. But the fact pattern in that opinion is there are two witnesses to a crime. Okay, the victim and a bystander. Then there are two other witnesses who couldn't identify the defendant in a photo lineup. And a third witness that actually said, I know the defendant and he's not the one who did it. And the prosecutor and the police decided that none of them were credible and didn't give over that information. I can't see that ever happening in Florida. I can't see that happening in Florida. You have a photo six-pack where where a witness who saw the event can't identify the defendant. That's released. You have a witness who is even a known liar on the street or a drug dealer or whatever who says, nah, he didn't do it. You know, you can't make an evaluation on credibility and say, nah, that guy's not credible, not going to give it out. That may happen in other jurisdictions. That doesn't happen in the 20 circuits in Florida. That's not who we are as prosecutors. But we have to live with the ABA opinion as it's written on those facts. Again, what is it that tends to negate the guilt or mitigates the offense? You know, just do the right thing. You all wear the white hats. I'm proud of each and every one of you for the job that you do. and the knowledge that you are seeking justice and not just convictions. Go with your instincts, but also know that when in doubt, you got to give it out. Especially if you're thinking, oh, this might be admissible, but it's not material. Give it out. Let's talk about internal affairs. This is probably one of the most misunderstood areas. I see this coming up time and again in appellate case law. I see this coming up time and again in trials. To what extent does the state have an obligation to turn over investigations, prior complaints, or IA findings? And this may surprise you as to what your obligations are and are not. First of all, inadmissible evidence cannot form the basis of a Brady violation. Period, the end. Starting with Wood versus Bartholomew, a U.S. Supreme Court case in 1995, a polygraph test is not admissible. Okay, therefore it could not have affected or altered the outcome of the proceeding. Again, you got to think about the ethical obligations, because are you obligated to give out inadmissible evidence? And the ABA opinion says, to a large extent, you are. That is in your possession or that is known to you. Again, the bar rule is an ethics rule that applies to the attorney. It's not one of those imputed things where if the police have this information and you don't, that good and bad faith don't matter. That's an ethical rule that applies to each and every one of us individually as attorneys, as members of the bar. So let's talk about inadmissible evidence in IA investigations. If an IA investigation is unrelated to the defendant's criminal charges, it's generally not admissible across the board, and thus does not satisfy the materiality element of a Brady violation. I'll take the most recent Florida Supreme Court case first. It involved an FDLE investigation of the sheriff and the prosecutor for misconduct in an unrelated case. It was not admissible found to be not admissible as to either substantive or impeachment evidence. What does that have to do with the case? Where is that admissible? That it's a potential prior bad act, but it's not a conviction. Why are we treating the sheriff differently than we would treat any other witness for purposes of impeachment? So let's talk about State versus Bullard. An IA found that the deputy made false statements to the public regarding salary issues in the sheriff's office unrelated to the defendant's case. Again, unrelated to the defendant's case. And I quote from Bullard, the investigation that resulted in Deputy Broom's suspension did not arise from the same incidents as Bullard's criminal charges, and it did not involve the use of excessive force, which I'll talk about in a minute, because it was completely unrelated to Bullard's case, or the theory of the defense case, I might add. We'll talk about that. It would not have been admissible. Accordingly, Bullard failed to establish a materiality element of a Brady claim. Now, officers under active prosecution are treated the same as any other witness. If you have an active prosecution of a police officer, well, basically, if that's a material witness, the state's either not going to call that witness and null-pros the case, or there are other material witnesses like the victim or other eyewitnesses or forensic evidence that support the case without that witness's testimony. But a law enforcement officer has the same motivation to curry favor with the state as any other witness. So under prosecution, absolute Brady disclosure, absolute on every case that officer is involved in, everyone. Let's talk about Breedlove. In a murder prosecution, the detectives were under investigation for unrelated criminal activity. It was drug activity. The witness, and this is a homicide case, the witness was not indicted until after trial. Okay, under investigation, but not yet filed. All right, the court held that where a witness is not under actual or threatened criminal charges, if it's like right at the precipice, that's Brady. But merely under criminal investigation, then it must be related to the case at hand. In other words, whatever the case is that they're under investigation for needs to be related to the actual case that's being litigated. Since the alleged criminal activity of the defendants was collateral to the issues of the murder case, they were inadmissible, and therefore there was no reasonable probability that the outcome of the suppression hearing or the trial would have been different. Let's talk about excessive force. That's a horse of a different color, depending on what the charges are. If it's a resisting with violence or a battery Leo or one of those type cases where there is a theory of the defense case that the cop used excessive force, any prior IAs are going to be admissible. Look at Michael versus State, 2nd DCA, again, resisting with violence case. And I quote, "The proffered questions regarding the officer's 5 prior complaints of excessive force could have provided the jury with a plausible motive for the officer to misrepresent the facts of the incident in an effort to avoid another complaint which could have led to disciplinary action." So it rose now because it's related to the defense of that particular case. If that were a burglary case or run-of-the-mill theft at Walmart, that's not relevant. That's inadmissible. Okay, but since it's a theory of the case that the police officer used excessive force, it now becomes relevant, and it now is a Brady materiality issue. Okay, Hinojosa versus State, the theory of defense, again, the LEO is the aggressor, and excessive use of force IAs are admissible. So Brady rears its head. Got to keep that in mind if you have those kind of cases. Other potential cases, Arnold versus McNeil, an officer involved in criminal activity, including dealing cocaine during the same time frame as defendant, where the officer was the only person to identify the defendant as a seller of drugs. You set me up. He's lying. I didn't do this. Well, that's impeachable information because it's contemporaneous. He's dealing drugs and he's getting rid of a competitor, arguably. Okay, Stripling versus State, the LEO in a bribery case where the entrapment was the defense, and the officer was under criminal investigation for other alleged shakedowns. You got an officer that had throwdown, evidence that would take, obviously if it could be proven beyond a reasonable doubt, that's not an internal affairs issue. That's a prosecutable issue if an officer is planting evidence. But say the complaints are coming in, and there are IA investigations about planting evidence, about throwdown guns or throwdown drugs, about entrapment, about excessive use of force. If it's the theory of the case and it relates to the case, it's going to be admissible. And it's if you have that information, you need to turn it over. Do you need to go out and get the information? To what extent? If you have an inkling that that's their defense, defendant has a due diligence requirement to go out. All it is a public records request for the IA file of the officer. But if your case is thin and it's just your officer's word, you might want to get the file and redact it, or at least talk to the defense attorney about, hey, why don't you go ahead and get the file. There are limits on cross-examination when this impeachment information comes in. The court does have discretion, as to limiting the defense and going into details on the same way if there's a prior conviction. You don't go into details on the conviction. The fact that there are 5 IA complaints, that's pretty much all the defense should be getting in on excessive use of force, not the particular facts of each one, unless it's a Williams rule type of issue where this guy says, I'm Superman and I wear a cape and now I'm going to beat you up. And it's all the same all the way through. It becomes similar facts, Williams rule that may be admissible for that purpose. But that ain't going to happen very often. So you can limit that cross-examination. Some practical considerations. Closed IA cases are subject to public records. They're available to defense. Defense can go get them. You don't have to do the defense case for them. Open IA investigations are not subject to public records, and not all open IA investigations are admissible. It would have to directly relate to the case. But if it does, you've got to consider that. You got to look at your case, and you got to consider what you're going to do with this witness. If there's a question of admissibility, an open investigation may be subject to an in-camera view by the court prior to the release and discovery. And lastly, prior complaints are admissible, potentially material, only when relevant, again, to the defense, to the crime charged. So, as I said, to what extent do you anticipate relevant excessive force defense in order an LEO personnel file? You have to look at that, think about your case, what you got. Clearly, the defense, you don't want a 3.850 if the defense doesn't get the file and it's admissible. And the knowledge and possession of the police is imputed to you. So you are risking a Brady violation reversal if you gain a conviction on thin evidence based on this officer's testimony when he's got a gajillion excessive force complaints and you didn't get it for the defense. Strategically, if you have an active prosecution, is the witness material? If the witness is material, think about null prosing. If the witness is material, but you have other material evidence that you can use and not have to call that witness, again, there's no impeachment issue if you don't call the witness, okay? If the witness is not material, you can strike the witness. In striking the witness, that should eliminate any Brady issue, impeachment issue. But I would submit it doesn't eliminate your requirement if you have impeachment information to hand it over. Remember, the listing of that officer on a discovery exhibit does not mean that officer is on the state witness list. So defense can't say, hey, that's the state witness list. No, it's a discovery witness list. You're not going to call him at trial. You let the defense know, I'm not calling this guy. Hell, let the defense know, this guy's got all these IAs. I get it, what you want to do about his, excessive use of force is a tough one because do you really want to prosecute that case? But if you do, and you have other witnesses and other evidence, just make sure you let the defense know. Now, say the defense now adds your witness to their witness list because they want to call your damaged, impeachable witness. Well, as you all know, a witness cannot be called at trial merely for the purpose of impeaching that witness. We can't call a co-defendant that's going to invoke their right to Fifth Amendment, to make the defendant look bad. Well, you can't call somebody who's going to give damaging testimony just to impeach that witness. I mean, there's a number of cases. The most recent one is State versus Surfrere. It's a 4th DCA case in 2019. The law enforcement officer was under investigation in another state for theft. The state did not call him as a witness. No Brady violation. Period, the end. No witness to impeach. Unless the defense can articulate a good reason, a good faith reason to call the officer, independent of the impeachment, you can move in limine, and you should move in limine, to strike or limit the testimony of the witness. A good faith basis obviously would be he's involved. He's got all these throwdowns. It's a defense theory of the case. This guy was the only one that was alone with the defendant, and there are these issues. I think you're on slippery slope right there to try to move in limine. And if he was alone with the defendant, why the heck are you prosecuting the case anyway? If there are that many complaints about him. So these are all determinations that you need to make in doing your due diligence as prosecutors and doing the best you can, not only for the people of the state of Florida, but also doing justice. Now we're going to talk about Brady lists. Now, how many of you in your circuit maintains a so-called Brady list? Well, good. Let's talk afterwards, after the presentation, because I want to find out how you maintain such a list. Now, remember this. Florida has one of the most open discovery rules system in the country. We give it out. There's no hiding the ball here. It's not the federal system. Public records, readily available. Any internal file, any internal investigation is public record once it's done, and it's available. And the defense, as we discussed, has a due diligence requirement to maintain their case, to make their case. If it's a case that involves excessive use of force, bingo, you go to the IA files to find out whether that defense that your client is telling you that that it was a response to aggressive or excessive force, then that'll be in the file. It's not rocket science. It's available. But the kicker is that 99% or more of internal affairs reps, even if they're founded, are not admissible. So how is this Brady? How does this become Brady? What if a cop has an overtime where they padded their overtime? Now it's not right to do that. And make no mistake about it, if a cop lies, if there's official misconduct on a report, I have personally prosecuted police officers for filing a false probable cause affidavit. That's criminal. But if it's not prosecuted and if there's not a felony conviction or a crime involving dishonesty, it's not admissible. If it's not admissible, it's not Brady. Who makes the decision as to what officer and how far the internal affairs investigations go to put that person on a Brady list and effectively ruin the career of a police officer? Now, I'm not countenancing complaints, especially if they're founded. But I will say this, and this is personal opinion, Brady list is political. It is not a legal doctrine in any way, because these internal affairs investigations are simply not admissible. Now, if you know about one and it relates to the case, or if you have a well-founded theory that the defense theory of the case involves, say, excessive use of force, like we discussed, yeah, you can go out and get it, but the defense has a due diligence requirement as well. Now, if your circuit does this, fine. And I'm just voicing my own opinion that the Brady list is unnecessary and political, and the 15th Judicial Circuit does not do it. We give out material that we have. We give out material if we have, and we'll look at an IA file if we feel that there is a likelihood that we're going to find something that is admissible. But to keep such a list, no, we do not do it in the 15th. If you do it in your circuit, fine. And again, this is my opinion that the Brady list is a political list and not a legal list. And of course, always, when in doubt, give it out liberally. We have open records laws and we have open discovery. Now let's talk about Giglio, our last run to the end of the session. Thank you very much for your attentiveness and not fast forwarding through this or sleeping. Giglio is a step beyond Brady. I mean, many cases talk about a Giglio like Guzman that we talked about earlier. They look at a Brady analysis and then they look at a Giglio analysis if it involves false testimony. The Giglio case itself, the prosecutor failed to disclose a promise not to indict a key co-conspirator who is the witness, the only witness linking the defendant to the crime. That was made by the previous prosecutor. The witness testified that no promises were made. Pretty clear cut. That's important stuff. That's material, okay? In terms of a jury deciding whether this was, the testimony is reliable or not reliable. So, in Giglio, the Supreme Court of the United States in 1972 said, when the reliability of a given witness may well be determinative of guilt or innocence, non-disclosure of evidence affecting credibility falls within the general Brady rule that suppression of material evidence justifies a new trial. Well, that sounds like Brady, But then let's go to the interpretation of burden of proof, of how egregious withholding false testimony is viewed by the courts and should be viewed by all of you. Like Brady, there's a three-pronged test. The testimony was false, that the prosecutor knew or came to know that the testimony was false, and that the statement was material. Okay, again, materiality, but we have to look at what the burden of proof and what the level what the standards are for viewing the materiality of a lie, basically an impeachment. Ventura versus State, which was affirmed, by the way, the witness testified that no promises were made in exchange for his testimony. A U.S. attorney correspondence revealed that the government agreed to dismiss bond-jumping charges against the witness. The court found the undisclosed impeachment info to be cumulative and the corroborative evidence of guilt to be strong. So there's an analysis that said it was a strong case, and there was a lot of other impeachment evidence. It was cumulative. Again, you got a tipping scale here. Don't do it. Now, again, the prosecutor has to be aware that this exists. This is something that the prosecutor is aware of. I don't suppose that anybody in this room that is actually aware. Now, of course, it could have been in the file and the prosecutor didn't remember it or didn't look at it. Well, be aware of your file before you go to trial about what your witness is offered, if your witness is offered anything. So the obligation of the prosecutor, Giglio stands for the proposition that a prosecutor has a duty to correct testimony he or she knows is false when a witness conceals bias against the defendant through that false testimony. That's Routley versus State, Florida Supreme Court in 1991. It applies to false testimony concealing substantive evidence as well as impeaching evidence, and that's from Richmond, another Florida Supreme Court case, 2007. But by and large, you're going to have impeaching information of witnesses that have been offered things. That's the majority. But you may have substantive, obviously substantive falsehoods as well. The obligation to correct is ongoing. This U.S. versus Alzat case, I'm focusing on this one. It's a 11th Circuit case, federal, but I'm focusing in on the prosecutor. Detective takes a stand, innocently says, the defense theory of the case is the defendant is a mule. The defendant made certain statements to the detective in a room where there was another box of cocaine that was unrelated to his case, okay? And the state used those statements about cocaine to say that this guy knew he was traveling with cocaine. He's not just a mule, he knew what he was doing. And that was the state's theory, that this guy, don't believe this guy, because his theory of defense was duress. I was under duress. But the nonchalant way he was talking about, or however he was discussing that unrelated box of cocaine, would indicate that he was that the duress might not have been a factor. Okay? The detective, after testifying that there was nothing in the room, came back to the prosecutor during trial and said, you know what, I thought about it, I looked at my notes, there was an unrelated box of cocaine there. The prosecutor did not correct the detective's testimony, did nothing to correct that testimony, continued to rebut the defense without disclosure, through closing argument, used his statements that the defendant was saying were based on this unrelated evidence. Now, the court said the matter could have been corrected by stipulation or by testimony from Agent Ostis. The jury could have been told that the box that was an integral part of Alzat's explanation did in truth exist. That is what should have happened. It did not. The reason matters went awry is that Boscovich, the prosecutor, by name, you don't ever want your name in an opinion like that. Boscovich, the representative of the government of the United States in that courtroom, chose to keep silent and not disclose his knowledge that statements he had made to the court and the jury were false. I put 36X on the top of this slide. That's how many times the appellate court put the name Boscovich in their opinion. And that doesn't count the footnotes. Don't do it. Don't ever do that. I can't put myself in the mind of the prosecutor as to why it wasn't corrected. It needed to be corrected. Anytime, at any time, when you determine that something was false or something has changed, and don't even have that materiality argument, you need to bring it to the attention of the court. Now, what is a Giglio violation? There has to be a trial. There can be, it's like Brady, there can be no, if there's no outcome, there's no Giglio violation. If you find out about a lie beforehand and it's corrected before trial, or if the witness does not testify, and in this slide we talk about the witness not testifying, that witness could be lying and have inconsistent statements all over the block, deposition, this and that and the other, and you haven't corrected anything, defense has all this information, so what? The witness didn't testify. There was no outcome that was altered. So in Jimenez versus State, if it doesn't go to trial, it cannot form the basis of a Giglio claim. Also Reichman versus State, Florida Supreme Court. So let's talk about prong one, false testimony. This is Giglio. Slight differences. There are never two witnesses that testify exactly the same because they have different perspectives. And if they do in detail, it's time to worry. It's like three people going to watch a movie, or going to a wedding, and they think of different things when somebody asks them, how was the wedding? And people's memories are the same way. People may remember things, there may be ambiguities or slight differences. That's not considered false testimony, okay? An appellate court will not disturb a trial court's finding of fact if supported by substantial evidence. And that's key here, because that's where the initial Giglio or Brady hearing is going to happen. You got Serrano versus State, you got Rodriguez versus State. They're both recent Florida Supreme Court cases. Post-conviction credibility issues are determined by the trial court. In other words, there may be inconsistencies in the testimony or the proceedings in the trial, but for example, he told me he was going to promise me leniency. Prosecutor says I did not. The guy didn't get leniency. That's a credibility issue as to whether that actually happened or not, whether that witness was offered a benefit for his testimony. And if the court comes down on the side of, there's no evidence here corroborating that he got a lesser sentence, and I believe the prosecutor, I don't believe, credibility-wise, it's not going to be a Giglio issue. It's taken care of at the trial level. Unclear testimony is not false testimony. Bogle versus State, another Florida Supreme Court case 2 years ago. Minor omissions, answers to specific versus general questions, that's not going to rise to prong one. The first thing, and defense, by the way, has the burden for prong one and prong two. Okay, that the defense, the statement was false, and the prosecutor did not disclose that false statement. Okay. Cumulative impeachment, material information was disclosed in Roudley, okay, and at a state level, they didn't think that it just didn't rise to a materiality level. Prong two, knowledge. The prosecutor must be aware of the false nature of the testimony. If it's uncovered later on in Duckett versus State, Duckett has two T's, I'm sorry. It's 2 years ago, Florida Supreme Court case. The defendant claimed that the FBI analyst's testimony was false and misleading at trial based on subsequent reviews of his work by the Department of Justice. The prosecutor had no idea the FBI findings were flawed at that time, or that the witness may have lied or misrepresented at that time, at trial. The court noted other significant evidence of guilt was introduced, but that's a different issue. The prosecutor has to be aware that the testimony at trial is false. And again, if it's just really minor, it's not going to rise to the level of being material. Prong 3, prejudice materiality. This is a much more defense-friendly standard of materiality, where the prosecutor knowingly uses perjured testimony. This is in United States versus Al-Assad. It's a federal 11th Circuit, case in 1999. It's also mentioned in Ventura and Routley in the state case. Prosecutor knows of perjured or false testimony, fails to correct what he subsequently learned was false testimony during the trial before the outcome. Under Giglio, a statement is material if there is a reasonable probability that the false statement could have affected the judgment of the jury. Now, the burden of proof, again, I said the burden of proof is on the defense on the prongs 1 and 2. That's U.S. versus Bagley and Guzman versus State, U.S. and Florida Supreme Courts. Once the defense established that, the state has the burden that the false testimony was harmless beyond a reasonable doubt. At State versus Dugan, 202 Southern 3rd, 363, Florida, 2016. The thrust of Giglio is to ensure the jury knows the facts that motivate a witness in giving testimony, and that the prosecutor not fraudulently conceal such facts from the jury. This is important stuff, folks. Really be mindful of, we can't just, massage the edges of this. This is the heart of what we do as prosecutors, to make sure that the jury knows that the testimony, if there is a conflict in the testimony, that the jury needs to be aware of that conflict when they testify at trial. Let's see, Dugan as well, we talked about Dugan. A material witness testified that his plea deal was for second-degree murder. Dugan is an interesting case because it definitely illustrates this point. He testified his plea deal was for a second-degree murder and a life sentence. Well, that wasn't true. That wasn't true. His deal was he pled open, and the ultimate the sentence was contingent upon his testimony, and he ultimately got 15 years. Now, I don't know how on earth the defense attorney was not aware of this. Maybe it was oral. I don't know precisely, because obviously the record is shortened with regard to the appellate decision. But that, if the prosecutor knew that, and that he wasn't going to absolutely receive a life sentence, it's up to the state to make sure that the jury knows that. So Dugan was reversed. Ambiguous promises. There are several cases that talk about, I'll take care of you, I'll speak a word on your behalf, is not sufficient to be a Giglio or a Brady issue. Again, facts are stubborn things. So you have to assess your case. There is case law that says it's up to the prosecutor to determine where something becomes exculpatory and where you reach the level of a Brady exculpatory statement. Again, your ethics, when in doubt, you give it out. But in Tarver versus Hopper, the prosecutor told the witness his testimony would be taken into consideration in reducing charges, and the witness testified he was not promised a deal. Well, that's pretty much true. He wasn't promised a deal. So, Tarver said that's okay. There are other cases that talk about that as well, but be mindful of the U.S. Supreme Court case, Napu. The co-defendant was a material witness. ID was an issue, and the witness was promised that if he would testify, the prosecutor would recommend a reduction in his sentence. Well, that's a promise to reduce your sentence. That's not a vague, ambiguous thing, I'll take it into consideration. Okay, so it is different. The witness testified at trial, both on direct and cross-exam, that no promises were made. But the prosecutor promised to recommend a reduction. Even though he didn't say, you're getting it, he says, I'm going to recommend it, and it's specific. The fact that the defendant was impeached on other grounds did not turn, quote, a tainted trial into a fair one. A new trial was mandated. Again, the fact that the prosecutor couldn't guarantee a reduced sentence didn't matter. Lastly, Michael Nifong. Those of you who have been around for a while, he was the DA in Durham, North Carolina, during the Duke University scandal, when a bunch of lacrosse players were accused of sexual battery. He knew and withheld exculpatory DNA information, material exculpatory information other than the DNA, and he actually went into court and said none existed. Exculpatory DNA existed when it did, and the fact was that the DNA from the items in the rape kit were from multiple unidentified males. When the issue came up in court, he denied knowledge. He was disbarred for life, and he was sentenced to 30 days for contempt of court for lying to the court. So don't be Nifong. Be ethical, be open, respect your position of power, and also make sure you keep defense attorneys on the hot seat, that they have to be ethical as well, and not hide the ball when it comes to witness lists and experts in the middle of trial. There is a two-way street when it comes to ethics, but the requirements of discovery, the requirements of Brady, and the requirements of Giglio are squarely on the prosecutor's shoulders. And accept that burden, accept it well, and again, when in doubt, give it out. Thank you very much. And we'll see you in a couple of years when we do this again with new case law.